We had our own way of dispensing justice, the alternative justice system. And so that experience will come in handy as a judge of the High Court.
So you would apply alternative justice system?
Yes, I will apply alternative justice where it's applicable, where it fits.
Okay. Now, sometimes domestic courts in Kenya grapple with the rules of customary international law and how they apply. Now, I want to ask you, what will be the principle that will be applicable in applying customary international law in court? Would it be as a matter of law or as a matter of fact? And also, if you can contradistinguish that with foreign law, how would foreign law be applied in Kenyan courts?
Thank you, Commissioner. Foreign law, especially the Commonwealth law, is persuasive.
Okay.
And
customary international law?
Customary international, once it has been ratified by Kenya,
yes,
it is applicable.
And if it's not ratified, it's a practice?
It is not applicable.
Okay. I thought there is a legal test before a court would arrive at that conclusion. Might you perhaps know what the test is?
The test whether?
The test on how Kenyan courts would apply customary international law.
Customary international law is applicable to Kenya if Kenya has ratified, if it's a treaty.
No, that one we've agreed on. Council, we've agreed on that one. What if it is not?
If it's not applicable.
Okay. I think maybe you just refresh yourself on that.
Thank you, Commissioner.
All right, then I want to give you a scenario. So sometimes we have our troops going for peacekeeping missions. It's a question that follows on this applicability of customary international law. We have our foreign troops who, from time to time go for peace missions. For instance, in Haiti, in the Democratic Republic of Congo, and even in Somalia. Now, those troops, when they are operating in foreign soil, would they have the power to detain a person in a foreign soil? And if such a person were to come to Kenya and say that they were...
The judicial officer will make a decision whether the accused has a case to answer or not. If the accused has no case to answer, and the defense maybe makes a submission on that, and if the judicial officer finds that the accused has no case to answer, he or she will be acquitted under Section 210 of the CPC. If the judicial officer finds that the accused has a case to answer, the accused will be put on his defense or her defense. They will also be called upon to call their witnesses and present their case. The prosecution will have the opportunity to cross-examine.
If I may interject a bit, at the point where the accused has been put on his defense, there's a step there you are missing. What happens before the accused gives their defense?
There will be submissions.
After submissions, the accused has been put on his defense, isn't it?
Yes.
Now, before the accused gives his defense and calls his witnesses, there's a critical step there you are missing.
The accused will be told to elect whether to testify by way of sworn statement or unsworn statement, or even have the opportunity to be silent.
Okay, now you can go on. So the prosecution has, the accused has called his witnesses and closed his case.
Once the defense has closed its case, both sides will make a submission, and after the submissions, the judicial officer will retreat to writing her or his judgment. And if the judicial officer finds that the prosecution has proved its case beyond reasonable doubt in a criminal trial, then the accused will be convicted, either sentenced to non-custodial sentence or custodial sentence, or a suspended sentence, or a community service order, or on probation.
The array of sentences.
Array of sentences. And
Okay.
if he is found not guilty, will be acquitted under Section 215 of the CPC.
Okay. Now, this court that you...
And the life experiences I've gained.
Thank you. Perhaps just to start from where you've left, when you say life experiences, do you mean that your life experiences will impact on how you judge people if you are to get this position?
It will matter.
How so?
Coming from where I've said I come from, for example, I grew up in a community where there was no access to justice, and we had our own way of dispensing justice, the alternative justice system. And so that experience will come in handy as a judge of the High Court.
So you would apply alternative justice system?
Yes, I will apply alternative justice where it's applicable, where it fits.
Okay. Now, sometimes domestic courts in Kenya grapple with the rules of customary international law and how they apply. Now, I want to ask you, what will be the principle that will be applicable in applying customary international law in court? Would it be as a matter of law or as a matter of fact? And also, if you can contradistinguish that with foreign law, how would foreign law be applied in Kenyan courts?
Thank you, Commissioner. Foreign law, especially the Commonwealth law, is persuasive.
Okay.
And
customary international law?
Customary international, once it has been ratified by Kenya,
Yes.
it is applicable.
And if it's not ratified, it's a practice?
It is not applicable.
Okay. I thought there is a legal test before a court would arrive at that conclusion. Might you perhaps know what the test is?
The test whether?
The test on how Kenyan courts would apply customary international law.
Customary international law is applicable to Kenya if Kenya has ratified, if it's a treaty.
No, that one we've agreed on. Council, we've agreed on that one. What if it is not?
If it's not applicable.
Okay. I think maybe you just refresh yourself on that.
Thank you, Commissioner.
All right, then I want to give you a scenario. So sometimes we have our troops going for peacekeeping missions. It's a question that follows on this applicability of customary international law. We have our foreign troops who, from time to time go for peace missions. For instance, in Haiti, in the Democratic Republic of Congo, and even in Somalia. Now, those troops, when they are operating in foreign soil, would they have the power to detain a person in a foreign soil? And if such a person were to come to Kenya and say that they were wrongfully detained, for instance, would they be entitled to constitutional damages?
when Kenyan troops are in a foreign country, like as you mentioned, Somalia or elsewhere, and they detain someone there, and they come back here to...
First of all, the question is, would they have the power or legal authority to detain a foreign national in their own land when
yes.
they're and that would be based on what?
It will be based on international, United Nations Convention, United Nations Treaty.
Okay.
Yeah.
And if that foreign national came to Kenya and sought for compensation for being wrongfully detained?
If the foreign national was detained in a foreign country, they cannot come and sue our officers here in Kenya.
Okay. Then lastly, sometimes we have controversy whereby the East African Court of Justice, makes a finding or a decision about an issue that concerns Kenya, and perhaps, overrules or states that a Kenyan court was wrong on an issue. Now, would that be binding to the Kenyan courts? No. And if not, why?
It's not binding on the Kenyan courts because Kenya is a sovereign nation.
But we are part of the East African Treaty.
We are part of the East African Treaty, but our constitution is supreme. The decision of the East African Court of Justice, for example, will not supersede the decision of our Supreme Court of Kenya. And so it's not binding.
Okay. Where would you get the authority to state that? What is the authority to state that?
There was the case of Mother Karua in the South African Court of Justice when she lost the election in Kirinyaga County. And she went all the way to the East African Court of Justice. And there was a decision in the East African Court of Justice. And our Supreme Court here said that the decision of our courts were final.
I think you might just have to refer again on that. But thank you very much, and I wish you well.
Thank you.
Thank you, Honorable Chief Justice. Wakili, let's do a fast forward. And you are now a judge of the High Court, sitting to hear and determine a civil suit in which a plaint was filed and service of the summons was effected upon the defendant. There is an affidavit of service to that effect. However, there was no memorandum of appearance that was filed, and neither was the defense filed. Please explain to us how you then proceed.
My lady, if you can kindly repeat for me.
I repeat, okay.
Kindly.
All right. It's a civil matter in court. The plaint, of course, has been filed by a plaintiff, and service of that summons was effected upon the defendant. The defendant has not filed a memorandum of appearance, and neither has he or she filed a defense. How then do you proceed?
My lady, thank you. In a situation like that, where a plaint was filed, service of summons was effected, and affidavit of service was filed.
Yes.
And the defendant has not entered an appearance,
yes,
nor filed any defense. I'll proceed to enter judgment.
All right. Do you do it suo moto, your own motion?
No. If the plaintiff files for an ex parte judgment.
We will need to be careful about terminology.
Okay.
So an application is made by, or as it were, a request for judgment is made by the plaintiff, and you enter judgment. Then please proceed from there.
Once an application is been made, I will ask for formal proof.
In what instances do you ask for formal proof, or in what instances do you proceed by way of formal proof?
Once an ex parte judgment has been entered and there was no defense, then I will ask the plaintiff to prove their claim.
Okay. Does it matter whether it was a liquidated claim or an unliquidated claim?
Yes, it will matter.
So tell us when you proceed by way of formal proof and when you do not proceed by way of formal proof.
When it is a liquidated claim, we'll proceed by way of formal proof. When it's unliquidated, we can't proceed by way of formal proof.
Maybe I can break it down further. So which one is a liquidated claim and which one is an unliquidated claim? Say somebody was asking, saying that the defendant gave me a check for 500,000 shillings which has bounced. Is that a liquidated claim or an unliquidated claim?
Liquidated claim.
And you're telling us that in that instance you would proceed by way of formal proof?
No, in the instance where it's non-liquidated.
All right. Supposing a memorandum of appearance was filed, but no defense was filed, how would you proceed? Memo of appearance filed, no defense filed.
Memo filed, no defense filed.
Yes.
I will enter judgment in favor of the plaintiff.
What about the involvement of the defendant, if at all?
If the defendant has not filed a defense,
yes, he has not
but
filed
they
a
have
defense.
entered appearance,
Yes.
then I will proceed to enter judgment in favor of the plaintiff.
If it is an unliquidated claim, which you have rightly told us that you would proceed by way of formal proof, my question is, what would be the involvement of the defendant in the course of your hearing?
Well, if the defendant has not entered defense and has not turned up in court, then there's no involvement.
Turned up would of course mean that he has been served or not served with a hearing notice. Do you call him to come to court if he has put in a memorandum of appearance but not?
Yes, I will ask the counsel for the plaintiff to serve again the defendant. Probably he or she may not have received the hearing notice. So I'll ask the plaintiff's counsel to prepare a hearing notice and serve the defendant again before I make a decision to.
Fair enough. Thank you. Thank you.
Okay, thank you, Honorable CJ and Wakili. Once again, Karim.
Thank you.
Now, under the 2010 Constitution, a person can acquire Kenyan citizenship in 2 ways. Maybe you are aware of the ways?
Naturalization by birth.
Yes.
And by naturalization.
That is, you mean registration?
Pardon?
You mean registration?
Yes.
Okay. Now, let's imagine a foreigner comes in to the country and somehow manages to get a Kenyan ID card and a Kenyan passport. By these documents, this foreigner is presumed to be a Kenyan, isn't it?
Yes.
ID
in
and
possession
passport.
of those documents.
Yes. You have these documents, you're a Kenyan, it's a presumption. Now, after some time, the state finds that the documents were not procured properly. And they file before your court now a petition for revocation of citizenship. Sitting as a judge, what factors would you consider, or what grounds would you expect the state to come up with for you to be satisfied that this citizenship ought to be revoked? They are claiming that this revocation was not properly acquired and it has to be revoked. What will you require them to prove?
I would expect the state to prove that the person is not born a Kenyan,
Yes.
that the documents that he or she was in possession, which now the state wishes to have it revoked, was acquired illegally and procedurally and without any right. And so I would expect the state to table that evidence and certify the court on how these documents were illegally obtained. The illegality has to be shown.
It has to be proved.
It has to be proved by the state.
Okay. Do you think, Wakili, do you think that there are instances where citizenship in Kenya can be presumed? We can presume citizenship on a person. Do you think there are instances like that?
I don't think. There's a
Okay.
presumption of citizenship.
Yeah.
You are either born in Kenya
Or you
or
acquire it
you
by
are acquired
naturalization?
through naturalization, through the legal process.
Okay, I wish you the best. Thank you.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon.
Is this the time you're allowed to drink water? Water break. I call it a water break.
Thank you. Thank you, Commissioner.
Okay. I have gone through your sample writings. You have shared with us submissions in ELC matter, constitutional petition, and election matters. So across all your sample writings, you demonstrate consistent legal competence, strong issue identification, and clear application of law to facts. They are well structured, logically reasoned, professionally toned, and you support your submissions with appropriate authorities. So I commend you for doing a good job.
Thank you, Commissioner.
So most customary laws in Kenya require the husband or the husband's family to pay dowry when performing customary marriages. And again, there are some customs that require, if there is divorce, that dowry be refunded. is the practice of dowry payment and dowry refund legal, or is it constitutional? Based on your response, please give further explanation.
Payment of dowry is constitutional, but refund of dowry is unconstitutional. Dowry is paid to the parents of the lady as an appreciation. It's not buying a lady. You don't buy a wife. You pay dowry as an appreciation. To say that dowry must be refunded is to say that you have bought this person, which is unconstitutional, because that is demeaning, is an attack on the woman character and humanity. It's against human rights, it's against our constitution. And there was a recent case, I think, in Kisii High Court, Justice Magare, where I think he said he directed, he made a decision that the wife has to personally refund the dowry. It was 2 cows and 50,000 shillings. And if the dowry was taken by her parents, she should go after her parents, but she must pay personally. I think that was very demeaning to the person of a woman.
Okay, I'm okay with that. Thank you, Chair.
Sorry, Chair, let me just ask him one or two issues about that. So what is wrong about a custom that demands that dowry is returned in certain instances? What will be wrong with that? Because if you read Eugene Cotran, you read even under the authors in Kisii customary law, there are exceptional circumstances whereby dowry can be returned. So what is repugnant about that practice?
What is repugnant about that practice is to demean a woman to the extent that, you know, when the marriage breaks down for some reason, that she must personally pay back that dowry. And sometimes that dowry is not paid to the girl, it's paid to the parents.
Not personally. We are not discussing Justice Magare's decision. We are discussing about the practice itself. Because what I heard from you say is that this would demean a woman. And yet, and I can give you an example, for instance, if for instance, the woman tried to poison the man and it was proved, or she was involved, quote unquote, with witchcraft, that dowry ought to be returned. It's the community that returns it, so that that relationship is completely broken. It is a practice that has been there for generations.
No, I'm not aware of that kind of a practice which has been there for generations, where a dowry, even if the woman poisons the man.
No, that is why you see we are discussing the law and customary practice, and you are making a statement, a general statement, not based on actual what do you call it, case law or authority in terms of those who expert evidence, so that when you say this is you must base it also on something.
I will base it on our constitution, article 159.3, which says that certain customs and traditions which are repugnant to morality is unconstitutional. And to me, the practice of forcing a lady to refund the dowry...
No, Counsel, don't get it wrong. It's not the lady who returns the dowry. You see, you are narrowing on this particular decision from the judge. The practice generally is that the dowry is returned by the community, because it's the community that receives the dowry. And those practices have been acceptable from where I come from, for instance. In exceptional circumstances, and also it's not general. There are certain instances whereby that dowry ought to be returned. So what is wrong with that? Because it's a practice that, and the Constitution says we recognize cultural practices, we recognize certain things that bring order and harmony in community.
Well, we recognize that, those customs and traditions that are not repugnant, but today the tradition of returning dowry, whether it is by the lady or by the community, as you have said, to me, it's repugnant, and it's not something that should happen today in this country.
Okay. All right. Thank you.
Yes. I want to test your knowledge of some of the Supreme Court decisions. My first question is, what do you understand to be the basic structure doctrine? Is it applicable in Kenya? If so, why? If not, why?
Basic structure doctrine is applicable in Kenya, and it's applicable. There was a Supreme Court decision, I think the case of BBI, where Supreme Court held that the basic structure doctrine is applicable in Kenya, and gave instances when the constitution can be changed through universal suffrage or through parliamentary process or through personal initiative.
Okay. Just explain to me the last bit. Through personal initiative, how?
Through either through parliamentary process or even by the president making a proposal for the change of the constitution, or maybe a group of people wanting to have the constitution changed.
Okay. Yeah. Thank you very much.
It's me. Yes. Okay, thank you, my lady. Good afternoon once again, Wakili.
Good afternoon, my lady.
Now, we are trying to test your judge readiness, should you be successful in your bid to become a judge of the High Court. I want you to walk us through the steps in a criminal trial from A to Z and what you consider in those steps.
Thank you, Commissioner. A criminal trial begins with plea taking. After the person has been charged and brought to court, the accused person takes a plea. The charge is read to the accused person, who either pleads guilty or not guilty. From there, two scenarios happens. When the accused person then pleads guilty to the charge, I'll take you through that first. The judicial officer calls upon the prosecution to read again the facts of the case to the accused person in the language that he or she understands.
Did you say when he pleads guilty?
When he pleads guilty.
Okay.
The charge, the facts of the charge are read to the accused person again, and the accused will be called upon to confirm or deny the veracity of the facts. If the accused person says the facts are correct, then a plea of not guilty, a plea of guilty is recorded. If he accepts, if he pleads guilty to the charge and the facts, plea of guilty is entered, and the accused will be called upon to to mitigate. After the mitigation, maybe the prosecution might also want to present any aggravating factors, and the person is then convicted, and a sentence will be passed, either a fine or a suspended sentence or a community service order, or be placed on probation.
My friends are waiting to engage you, so we may need
Yes.
to rush it a bit. Yes.
So that is when the accused person pleads guilty. If the accused person pleads not guilty, then a plea of not guilty is entered. The judicial officer goes ahead to make a decision on the bail and bond, and fix the case for hearing. Once the hearing takes place, the prosecution will present their case, the witnesses, their evidence, but before that, the accused is provided with all the witness statements and documents that the prosecution might wish to rely on. Once the prosecution has presented its witnesses and documents, and they close their case after the cross-examination by the accused counsel, the prosecution closes its case, the judicial officer will make a decision whether the accused has a case to answer or not. If the accused has no case to answer, and the defense maybe makes a submission on that, and if the judicial officer finds that the accused has no case to answer, he or she will be acquitted under section 210 of the CPC. If the judicial officer finds that the accused has a case to answer, the accused will be put on his defense or her defense. They will also be called upon to call their witnesses and present their case. The prosecution will have the opportunity to cross-examine.
If I may interject a bit, at the point where the accused has been put on his defense, there's a step there you are missing. What happens before the accused gives their defense?
There will be submissions.
After submissions, the accused has been put on his defense, isn't it?
Yes.
Now, before the accused gives his defense and calls his witnesses, there's a critical step there you are missing.
The accused will be told to elect whether to testify by way of sworn statement or unsworn statement, or even have the opportunity to be silent.
Okay, now you can go on. So the prosecution has, the accused has called his witnesses and closed his case.
Once the defense has closed its case, both sides will make a submission, and after the submissions, the judicial officer will retreat to writing her or his judgment. And if the judicial officer finds that the prosecution has proved its case beyond reasonable doubt in a criminal trial, then the accused will be convicted, either sentenced to non-custodial sentence or custodial sentence, or a suspended sentence, or a community service order, or on probation.
The array of sentences.
Array of sentences. And if he is found not guilty, will be acquitted under section 215 of the CPC.
Okay. Now, this court that you seek to join has a huge problem of backlog. Can you tell us, in the 2024-2025 SOJA report, what was the case clearance rate for the High Court?
Overall, I think it was I think 60%
case clearance rate.
The High Court.
Have you seen the SOJA report?
Yes, I did. I've seen
it.
I've read it. Only that I can't remember the figure. But there is a backlog in the High Court. Okay.
The case clearance rate is 117% for the High Court.
That is okay.
Okay. So now can you share with us briefly the innovative ways with which you can contribute in case clearance as well as backlog reduction in the High Court?
I would, in my court, that is, I would speak for myself, I would categorize the cases. Because if maybe I'll be in a criminal division or in civil division or commercial division. Or
imagine you are handling all.
If I'm handling all, I will categorize the cases into three. One category of small claims, those with value of less than $1 million shillings. Fast track cases where the facts are uncontested, and those cases where the facts are contested. For the cases where it's not contested, I would list them for hearing on a Saturday. And I think I'm not reinventing
on a Saturday?
the wheel. Yes, because the Chief Justice is piloting in Kibera Court. For the uncontested cases, I will reserve them for Saturday and I'll clear them on Saturday. For the small claims, of course, they'll go to the small claims court. For the contested, I will hold a pre-trial conference, give pre-trial directions, narrow down the issues, bring on board the court users, bar bench, ensure that I give clear directions on how those contested cases will proceed. I will be also a screening officer. As a judge, I will screen all my cases, all the files that come before me, I will screen them and see those cases which are ripe for ADR and AJS. I will divert them under section 159(2)(c), section 59(b) and 59(c) of the Criminal Procedure Act, Civil Procedure Act, under the Civil Procedure Court Annex Mediation Rules 2022 and section 5 of the rules.
Okay, you'll explore ADR, in short.
I will explore that. I will do it for every case except sexual offenses.
Okay.
And I will not wait for any party to raise it. I will raise it myself as a judge because of the backlog.
Okay. Okay, thank you, and I wish you well. Thank you, my lady.
Just one thing. Now, Mr. Abdi, you have proposed that in a bid to clear backlog in the High Court, you look forward into sitting on a Saturday so that you clear those matters which you as fast as possible. That's a good initiative. But the scheme of things in Kenya now is that courts sit on weekdays, Monday to Friday. Do you think you need the permission of the Honorable Chief Justice for you to be able to sit on Saturday, or you can just do it suo on your own?
Well, the Chief Justice has pronounced herself on that about a week ago, and the Saturday sittings is being piloted in Kibera Court. However, I would still do the same in consultation with my principal judge, and only if the scheme of things, as you have rightly said, allows, I will not do anything illegal. But in an effort to clear backlog in my court, I wouldn't hesitate to sit on a Saturday if the law allows.
So I'm coming back to that issue. Do you think, in your own, do you think you need the permission of the Honorable Chief Justice to be able to sit on a Saturday?
Through the principal judge, yes, I do.
Okay, thank you.
Thank you, Honorable Chair, and welcome again, Mr. Abdi. Now, one or two questions from me. How will you apply the principles and objectives of Leadership and Integrity Act in your work as a judge, as a High Court judge? First of all, what are those principles?
The principles of leadership and integrity is impartiality, integrity, accountability, transparency, efficiency.
Okay. Go ahead and say how you'll apply them.
I would ensure that my decisions are not influenced by external forces. I will be impartial. I will ensure that there is no corruption in my court. I will declare under the Leadership and Integrity Act my assets, my liabilities, and I will uphold the constitutional principles.
Okay, very well. Now, I have some feedback here from the public and the stakeholders, but I would want to hear from you what you think, or what do you think the stakeholders or even the public, how do they describe you?
How the public describes me? Well, I don't know how the public describes me, but
what do you think people say about you?
They say I'm firm. They say I'm firm. I'm not corruptible. I'm uncorruptible. Firm, focused, and they say he sets his goals. He's not easily swayed, and believes in what he does and what he says.
Okay. Yeah. That is very true. There are no integrity issues that were raised against you. They also, of course, say you are of good temperament. You are calm to all the people who interact with you, which is good. But however, how long did you work with the NLC? Or are you still there?
No, I'm not there. I worked only for a year.
Okay, because there are some stakeholders who say that you were unreliable when you were at NLC. What do you say about that?
When I was?
At NLC.
Well, when I joined NLC, when it was first started under the 2010 Constitution, I didn't work for long. I worked only for 1 year.
Okay.
I was initially posted here at Nairobi, then to Nyeri, and I left NLC through mutual consent between me and the employer, National Land Commission, because I told them I will not work in Nyeri.
Okay. So you resigned?
Yes.
Okay.
Yes. By consent.
You had a problem working in Nyeri?
Well, it was at the beginning when there were a lot of hiccups. There were no facilities. There was no office. And I was told to go and hang around the county commissioner's office. And I didn't find it productive for me to just go and hang around there and earn salary. And I told them I would rather leave. Yeah. They just wanted me to earn salary and just stay there. But I said, no, I wanted to work. Yeah, and there was nothing because they were still putting their structures together. Okay. So there was nothing. But they just wanted me to be on the payroll. But I said, just keep the money, put it into use elsewhere.
Okay. Yeah. Thank you. I wish you all the best.
Thank you. Thank you, Honorable CJ. Before I ask my question, just a write down what Commissioner Kisotu was asking. Resources in the judiciary are very lean. We operate almost we are very stretched when it comes to resources, and I don't know what you're going to do if you're successful and you're posted in a station that you have to make do with what is available to serve Kenyans. Are you also going to leave?
Oh, no, I'm not going to leave. And I mean, I'm not interested in those resources. I mean, whatever I get will be enough. Again, the judiciary and that incident probably of the National Land Commission is not the same. Judiciary is well established. The resources, of course, are strained everywhere, not only in the judiciary. But I'll be happy to work anywhere with the little resources. I am 57 now, and I think I don't need extravagancy. With the little that is there, I would discharge my duties, even under a tree. Even under a tree.
All right.
Even mobile. If I can be able to reach the farthest corner of this country, I won't mind.
Fair enough. What would you say is your greatest motivation to apply for this role? What is really pushing you?
Well, I really want to we all look, we all have ambitions. I've come from very far, as I've told you. And I had set my eyes on the ball a long time ago. I'm still in the journey. And I think once I land in the High Court, I would be comfortable to discharge my duties and say I have reached the pinnacle of my career.
Okay. Please describe yourself as a leader. What is your leadership style and how would you describe yourself?
Well, I'm very caring. I work, I like working collegial. I like listening. I like consultation. I respect everybody, whether you're junior to me or you're senior to me, whether you're rich or whether you're poor. I don't differentiate. Power doesn't shake me. I have seen it. And money doesn't also worry me. I've lived without money, and now I have money. So I respect everybody, and I expect also respect.
Okay. In your various roles as a leader, have you encountered the younger generation in the workplace, the Gen Zs and the millennials? And if so, what has been your experience with this group?
They need mentoring. The young generation, they need to be mentored. Of course, they are in a different times from ours. They want to get it very quickly. They don't observe time. They rush to judgment. And therefore, they are a very difficult lot. But they need to be mentored.
Okay. So you encounter with the ones you've encountered, you find them very difficult to deal with? Because that's the biggest population in the judiciary.
It's not difficult, but we need to nurture them. We need to tell them why it is 8 to 5 or 9 to 5, why you must clear your desk, why you must do what you have to do, why you have to be patient, why you have to work hard, why you have to appreciate what you have and look for what you don't have. They constitute a large population, a segment of our population, yes, but we are different. Our time and their time, when they are growing up and when we grew up, our times are different. They have everything, technology on their fingertips. Education is almost free. They can access, but they are not patient.
Okay. I will take that. Thank you, and I wish you well.
Thank you, Commissioner.
I think it's afternoon now. Good afternoon.
Afternoon,
Yes.
Vice Chair.
Can you relax ama umechoka?
Niko sawa.
Uko sawa.
Niko sawa.
Who are the key stakeholders in the justice sector? And how would you effectively engage with key stakeholders in that sector?
Key stakeholders, the National Council on Restoration of Justice, the ODPP, the public, LSK, Parliament, the executive. These are all very important stakeholders.
How would you effectively engage with these ones, with them?
I would engage with them, some of them, like the Law Society of Kenya, through the Court Users Committee, through the Bar Bench Committee, the prisons, the police, all through the Bar Bench Committee. The judiciary is already engaging with Parliament and the executive through the soldier report, which is a statutory requirement every year, like we had last year, through the National Council or Administration of Justice, where all these stakeholders sit. The judiciary engages with them. But for me as a judge, then the channel through which I can engage is through the Court Users Committee and the Bar Bench Committee.
How would you handle criticisms from the public or media regarding your decisions?
I will take it in my stride. I wouldn't overreact. I will take it positive. If I'm wrong, I admit I'm wrong. I correct myself. If I'm right, I believe I'm right, I will stand firm. But I will not react to it, especially the media and the social media and the mainstream media. I would stay away from it.
Thank you.
Yes, this is almost coming to an end, Mr. Abdi. Just the last one on the area of general practice. I want to know from you the meaning of a decision of a court that is made per incuriam.
I can attempt per inquirium is a decision that is made in a bench of 2 or 3, without any dissenting voice.
Okay, I think I will not belabor that. I will just ask you to go and refresh yourself.
Thank you, Madam.
On what is a judgment made by incurium. But thank you very much. And on behalf of the Commission, wish you well. But before we release you, we always give the candidate an opportunity also to engage with us.
Thank you, my Lady Chief Justice and the Commissioners. I want to thank the Commission for having given me this opportunity to appear before you. I don't take it for granted. There were many applicants, but I got this opportunity. I have stated my case, and I leave the rest to God. and to this commission. And I want to thank you all and wish you the best.
Very, very well. We also thank you, and we'll get in touch with you when we complete the exercise. It's a very competitive exercise, but we wish you well and encourage you to continue doing the good work that you're doing to serve Kenyans in the various positions that you occupy.
Thank you, my lady.
Yes, have a nice afternoon. You can carry your writing pad and your water.
Thank you, my lady.